Your Honor, the defendants in this case, Ms. Jarrett or Ms. Humphrey and Mr. Humphrey filed the appeal from the Justice Court by filing a statement of inability to pay. Justice Court judgment was rendered on January 8 of 2026. That was appealed on January 14, and a registry payment was made to the Justice Court registry on or before January 20 of 2026, pursuant to Rule 510.9C, 5B, little, well, I guess it's no Roman numeral 2. The defendants were required to continue to pay their registry payments into the county court registry. I believe that a payment was made for February in the amount of 1,314. So in total, the amount is that $2,628 in the court's registry. However, we're now into the month of March. March's rent has become due, and as of yesterday afternoon, the defendants had not tendered the March rent into the court's registry. So we are seeking an immediate writ of possession here today for the property under the former, Texas Rule of Civil Procedure 510.9C that applies in this case as it was filed prior to January 1st of 2026.
Thank you. Mr. Humphrey and Ms. Humphrey, did y'all make that payment for March?
I haven't yet. I was told by the court that I had until the end of the 5th. So I honestly didn't know. So I have the court email. So
Okay.
I don't know what information Aaron has, but that's just the information that I was given by the court.
Okay, thank you. It is by the end of the day on the 5th day of the month. And today is the 5th. So I'm going to deny the motion for the immediate writ, and we'll go into the main part of the case then. Ms. Boyd, do you have an opening statement?
Yes, Your Honor. This case is a non-payment of rent case. My client is seeking possession of the property from Mr. Humphrey and Ms. Humphrey. They're also seeking award of the back due rent that is due and owing. And I believe the evidence in this case is going to show that my client has a superior right to possession of the property, as well as a right to recover the monetary sums for the unpaid rent and the attorney's fees that my client has expended in this case, as well as interest on any judgment that would be rendered.
All right, thank you. Mr. and Ms. Humphrey, do you want to give an opening statement as well? In fact, before you do, since y'all are going to be essentially testifying, I'm going to go ahead and swear any witnesses in. If you're going to be testifying today, go ahead and raise your right hand. Let me go ahead and swear you in ahead of time. Do you solemnly swear or affirm the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes.
Thank you. Everybody said, I do. All right, perfect. All right,
Yes.
Mr. or Ms. Humphrey, anybody want to give an opening statement?
Yeah, well, I really don't have much to say. I didn't submit any evidence because everything that I've done has been in good faith. The whole reason that I even wanted to go with the court hearing instead of talking with Quavius about the rent originally in November is because I was looking for mediation, because I was under the impression that there was retaliation involved. And, like I said, I came here in good faith, hoping that I would be able to see justice, that I would be able to receive some sort of mediation for just the whirlwind of confusion and just honestly weird behavior that I've gotten from Quavius and Jasmine. And I just didn't expect eviction court to be like this. I didn't expect judges to not look at the evidence, automatically side with the landlord. So it was new for me, but I'm a Christian. I submit to the Lord Jesus Christ, and he's the one who has been giving me he's the one who told me they retaliated. And so I came here in faith that I would see the evidence of my faith. And Quavius's email to me on, I think it was shortly after the hearing, before I filed the appeal. I had thought to myself, well, maybe they didn't retaliate. That's what they said. They said they didn't retaliate. And then I saw his email, and he was essentially mocking me in the email. And so I said, okay,
Your
well,
Honor.
Lord, what do I do? And so
Hold on. You're starting to testify, and all I needed was an overview of the case.
okay,
So,
well, I'm letting you know that I submitted the appeal, and it was 2 days past the deadline, but it was still accepted. And so I'm just here. That's
okay,
just
all right,
that's my statement. That's
okay,
I'm not fighting anybody. I'm just here.
okay, all right. Thank you.
You're
All right,
welcome.
Mr. Boy, you may present your case in chief. Call your first witness.
Thank you, Your Honor. The plaintiff calls Quavius Griswold.
Thank you. Unless you're testifying, go ahead and put yourself on mute. Thank you. All right. Mr. Boyd, you may proceed.
Thank you. Mr. Griswold, where do you work?
At Shelby Ranch,
All right, what's your position there at Shelby Ranch?
the community manager.
And you are appearing as authorized representative of Shelby Ranch Investments LP, the plaintiff in this case?
Yes, I am.
Okay, and you're familiar with the tenancy of Miss Aaron Humphrey and Mr. Michael Humphrey?
I am very familiar.
Okay. Do they reside at 2210 Lynbrook Drive, apartment 1432 here in Austin, Texas, 78748?
Yes, they do.
Okay. And their occupancy at the property, is that governed by a written lease agreement?
It is, yes.
Your Honor, would you like me to go ahead and share my screen?
Yes, please.
Okay. All right. Mr. Griswold, do you see my screen here?
I do.
Okay. Is this a true and correct copy of the lease agreement between Shelby Ranch and the Humphreys?
This is correct.
Okay. I'm going to scroll down here to the bottom. Lease agreement is electronically signed by both the defendants, correct?
Correct.
Okay. And this hasn't been amended, but for my marking of Plaintiff's Exhibit 1?
No, no amendments have been made.
Okay. Your Honor, we offer Plaintiff's 1.
All right. Any objection to Exhibit 1? Hearing none, Plaintiff's Exhibit 1 is admitted.
Mr. Griswold, on page 1 of the lease under box C, what is the defendant's monthly rent?
$1,314.00.
And has the Humphreys failed to pay rent beginning in November of 2025?
That is correct.
Have they also now failed to pay rent for December 2025, January, February, and March of 2026?
That is correct.
So under paragraph 3 and 3.5 of the lease, is failure to pay rent and all other amounts due a violation?
Definitely.
All right. And if I'll go ahead and scroll down here to paragraph 23.1, is failing to pay rent, including all the charges under the lease, a default of lease which entitles Shelby Ranch to possession of the property.
Yes.
Are you seeking an award here today of back due rent of $1,314 for each of the months of November 2025, December 2025, January, February, and March of 2026?
We are.
All right, and that would total $6,570, correct?
That is correct.
Now, under paragraph 23.5, are you seeking Shelby Ranch's reasonable and necessary attorney's fees here today?
We are.
Are you seeking post-judgment interest on any monetary judgment that would be rendered in the amount of 6.75%?
We are.
And are you seeking your costs of court from the eviction?
We are.
Mr. Griswold, I'm pulling up what's marked as Plaintiff's 2. Do you recognize this document?
I do.
Is this a true and correct copy of the notice to vacate that was delivered to apartment 1432 on November 10 of 2025?
That is.
And but for my marking of Plaintiff's 2, has this document been amended?
No amendments.
Okay. Your Honor, we offer Plaintiff's 2.
Any objection to Plaintiff's Exhibit 2? Hearing none, Plaintiff's Exhibit 2 is admitted.
Mr. Griswold, I'm going to go ahead and go down here. Did you deliver the notice to vacate?
Yes, I did.
All right, and did you hand deliver that to Miss Humphrey?
Yes, we did.
Okay. Mr. Griswold, I've pulled up what's marked as Plaintiff's Exhibit 3. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the resident ledger or accounting for apartment 1432?
That is correct.
Okay. And this indicates that the last payment received that was not returned for insufficient funds was on October 15 of 2025, correct?
That is correct.
Okay. Your Honor, we offer plaintiffs 3.
All right, any objection to Plaintiff's Exhibit 3?
I have one. Jasmine was the one who handed me the notice to vacate.
Okay,
Quavius-
hold on. I just
Mhm.
need a legal objection to Plaintiff's
Okay.
Exhibit 3. Do you have one
Okay.
for Exhibit 3?
Well, it's just incorrect information that.
Well, and you can challenge that, or you can
Okay,
talk
well,
about it.
all right. Then I don't have any objections to.
Okay, all right. You'll have a chance to talk about all
Okay.
this here in just a minute. Exhibit 3 is admitted.
Mr. Griswold, has the defendants, they're still in possession of the property, correct? You don't have keys?
We do not have keys from them. They are in possession.
Okay, and as of today's date, you have not received payment for the full amount that is due and owing?
That is correct.
Okay. Your Honor, I pass the witness.
All right, thank you. Mr. or Ms. Humphrey, do you have any questions for this witness? Do you have any questions for him?
I don't really have any questions other than just
Okay.
like asking Quavius, is it typical protocol for both of the managers to hand a notice to vacate to a tenant?
We do that. That would be a witness.
We can't hear you.
I can't hear you.
Hold on, we can't hear you. You sound like you're underwater. Your microphone's been pretty blurby up till now. We've been able to hear it, but not very well on that.
How about this? Is this a little bit better?
A little bit better.
Yes.
You just need to be closer to the mic because it's picking
Okay.
up. It's kind of
I'm
one of
sorry.
those big mics.
To answer that question, yes, we do use that as our standard protocol. That way there is a witness to the notice of delivery. So Jasmine and I, we or another leasing team member will accompany the person that's hand delivering.
Okay, and may I ask why you need a witness?
We would like to have a witness in the event that a resident wants to share that they were retaliated against or that there was any form of misconduct. Having more than just one associate provides that witness.
Okay, and there is an option in the notice to vacate to leave it on the door. May I ask why you didn't leave it on the door? Why did you decide to hand it in person?
Because that was an option. Hand delivery is an option, and that's the route we chose to take.
Okay, and when you knocked the way that you did, why did you choose to knock that way?
Your Honor, how is this relevant?
It's
I
relevant
don't-
because
Hold on.
okay.
You
I'm
don't
sorry.
talk. You don't
Okay.
talk. She's made an objection. Okay.
Yes, sir.
All right. So the objection is relevance. I need your response why you think it's relevant.
Okay, I think it's relevant because I raised a retaliation claim, and the way that he knocked was, in my opinion, unprofessional. It was inconsistent with the kind of news that they were delivering, and I was just asking him why he knocked that way.
All right. I'll allow, but I'm not going to go very far into this. So
Okay, well, Quavius, can you demonstrate the way that you knocked on my door, please?
I will answer the question first. Our standard
Okay.
protocol, we will knock twice before we enter. The reason why we did not enter and post on the inside of the dwelling was because Jaron Humphrey opened the door. We knocked very standard. There was no aggression in that knock. I simply knocked like this
I
to
can't
make
hear
sure
it.
that I was heard.
all
I
right.
can't hear.
Thank you.
I couldn't hear it.
It doesn't matter,
Okay,
honestly. Let's move
that's
on. Is there
fine.
any other questions you have for him?
Not right now.
Okay. All right. Thank you. All right. Mr. Boyd, do you have any other questions for Mr. Griswold?
No, I do not.
All right. Thank you. Sir, you're excused. Mr. Boyd, do you have any other witnesses?
Your Honor, I just need to call myself for attorney's fees.
All right. Thank you. You may proceed.
My name is Aaron Dubois. I'm a licensed attorney here in the state of Texas, and I was licensed in November of 2016. I practice with Rogers Law Firm here in Central Texas, and my primary area of practice is representing multifamily housing owners and management in litigation. I was asked to represent Shelby Ranch, the plaintiff in this case, and agreed to do so on an hourly basis. I charge $350 per hour and bill my time in tenths of an hour and tasks performed. In this case, I have reviewed the facts of the defendant's tenancy with my client's representative. I've reviewed the lease, the ledger, the notice to vacate, the justice court filings, the justice court answer from the defendants in this case, and some of the other ancillary documents that were filed in justice court. I reviewed the applicable statutes. I drafted the supplemental petition in this case, the notice of rent default. I prepared to conduct this trial and now tried this case. And in my opinion, the tasks that I have performed have been usual and customary. And I'm familiar with the guidelines set forth by the Supreme Court of Texas concerning attorney's fees and believe that I have adhered to these guidelines in all respects. It is my opinion that a reasonable and necessary fee for the usual and customary services rendered on the behalf of plaintiff in this case is an amount of $2,000. If this case were to be subject to a post-trial motion, I think a reasonable and necessary fee to handle that on behalf of Shelby Ranch would be an additional sum of $1,000 in attorney's fees. If this case were to be appealed to the Texas Court of Appeals, the task necessary to represent Shelby Ranch in that case would be to review the docketing statement, the clerk's and recorder's record, review any appellate brief, and drafting a responsive appellee's brief. And based upon my hourly rate of $350 per hour, I believe a reasonable and necessary fee to handle that on behalf of Shelby Ranch would be an additional sum of $5,000 in attorney's fees. If this case were to be subject of a petition for review to the Supreme Court, the task necessary would be to further review the clerk's and reporter's records, review the petition, drafting a responsive pleading. Based on my hourly rate of $350 per hour, I believe a reasonable and necessary fee would be an additional sum of $5,000. And if this case were to be granted a petition for review, I would further review the clerk's and reporter's records and review the full brief on the merits and draft a full responsive brief on the merits. And I believe that attorney fee, a reasonable and necessary attorney fee for that representation would be an additional sum of $5,000. And all of those amounts would be contingent upon my client prevailing in each stage post-trial. Your Honor, I have provided to the court via box, and I can screen share if you'd like.
Please do so.
There we go. Plaintiff's Exhibit 4. This is a true and correct copy of my activities export with Rogers Law Firm showing the work that's been done on this case prior to today's trial. And I offer that.
Any objection? Okay, hearing none. Plaintiff's Exhibit 4 is admitted. Mr. or Ms. Humphrey, do you have any questions for the attorney regarding fees?
No questions.
Okay, thank you. All right, Ms. Dubois, anything else?
No, Your Honor, plaintiff rests.
All right, thank you. All right, now, Ms. Humphrey and Mr. Humphrey, as I promised, you have an opportunity now to present any testimony or position that you'd like. No legal argument, but certainly facts that are presented would be appreciated. The legal argument you can do at the end when we do the closing statements. But as far as discussion of the facts, either one of you may call one another to testify. You can testify in narrative form. Ms. Humphrey indicated she didn't download or didn't bring any exhibits or documents, but she certainly indicated she wanted to say a few things, and maybe Mr. Humphrey as well. So would you like to call someone to testify?
No, sir.
Not at all.
I don't have any. Well, I don't have any witnesses. I just
Do you want to call yourself to testify?
Yes, sir. Sorry.
No, I just want to make clear okay. Yeah, that's fine.
Okay.
Ms. Humphrey, you may testify in narrative form, or you can have Mr. Humphrey do the direct questions and answers. But you can just testify in narrative form. You don't have to ask yourself a question like you're a third person or anything. You just kind of testify. Go ahead.
Okay. Well, I'll try to keep it short because I don't want to break any rules. I just my testimony is that I believe that Quavius and Jasmine retaliated, or they acted in retaliation, and I don't believe that Quavius has been completely honest and forthcoming, either with his superiors or with Aaron. If she knows, I don't, whether she knows the full truth, I don't know. But I just don't believe that there has been full honesty. So
Okay.
that's the testimony that I have.
Okay. All right. Mr. Boyd, do you have any questions for Ms. Humphrey?
No, Your Honor.
Okay, thank you. Mr. Humphrey, do you wish to call any witnesses or would you like to testify?
There's nothing, sir. I didn't find out about these problems until it was basically too late. So,
Okay.
if I can get a payment plan on this, see what we can do.
Okay. All right. Thank you. All right. Unless there are any other witnesses, I think the defendant has rested. So we're now ready to proceed with closing statements. Ms. Dubois, do you have
Yes,
one?
Your Honor. Evidence here shows that my client does have a superior right to possession of the property due to the failure of the defendants to pay rent. Concerning any claim for retaliation, Texas Property Code 92.33 I believe, states specifically that notices to vacate for non-payment of rent are statutorily non-retaliation. And so my clients have not retaliated per the Texas Property Code, and we are seeking possession as well as the award that is owed for the back due rent and the attorney's fees.
All right. Thank you. Mr. or Ms. Humphrey, do you have any closing statement you'd like to offer?
I have a quick question. So if there is an ongoing case and a landlord acts in retaliation as the case is ongoing, is that something that the judge is able to hear about?
I normally don't answer questions in closing statements. It's as far as the order goes. If there's something that you wish to complain about after an eviction has begun, that's probably a separate issue completely.
Okay.
What this court is dealing with right now is a contract, a notice, and whether there's been a breach of the lease,
Okay.
and whether the eviction is valid under law.
Okay.
Any other things you would have to deal with separately, I think.
Okay.
But this is the only thing I'm dealing with right now is the pleadings in front of me, and
Okay.
what was argued today, and what evidence was presented today.
Okay.
Okay. Anything else?
That's all. Thank you.
Okay. All right. Thank you very much. All right. Court will find in favor of the plaintiff as far as the lease agreement not being complied with as far as payment goes. I'll find that the plaintiff is entitled to possession of the property, that the defendant is liable for the sum of $6,570 and any court costs and post-judgment interests minus the amounts that are already in the registry of the court, which I believe is 2628 already. I'm going to also find that the attorney's fees to be awarded to the plaintiff are $2,000, and then there will be conditional fees. These are only if these conditions occur. If there's a post-judgment motion and hearing and the plaintiff is successful, attorney's fees will be awarded to the plaintiff of $1,000. If there's a court of appeals matter and the plaintiff is successful, 5,000. If there's a petition for review before the Texas Supreme Court, and the plaintiff is successful, 5,000. And if the court grants a petition for review, and then here's the case, and the plaintiff is successful, then an additional $5,000 in attorney's fees will be awarded. I'm going to set the supersedious bond on this matter at, hold on just a second. I'll set the supersedious bond at $3,942. Wait a minute, did I do that math right? Yeah. $3,942, which will be due within 10 days of this order. And then continuing amounts in the event the case continues on appeal, the sum of $1,314 will be due by the 5th day of every month thereafter, successive month thereafter, as the appeal continues. So that means that it would be due by April 5th of 1314. Those are the additional amounts if the appeal goes forward. And I presume there's already an order for me to sign, but if not, y'all can send that to me.
Your Honor,
And-
I've sent a proposed order to
Okay.
Ms. Rains Walker. Do you want me
Okay.
to go ahead and e-file that as well?
No, if you've already sent that to Ms. Walker, I'll take care of that.
Okay.
All right. Thank y'all for the courtesies. And I'm sorry things have turned out the way they have. And I'm
I'm
gonna let
sorry.
y'all go. I need to move along. Thank you.
It cut
Y'all are
out and
excused.
I couldn't hear you. Is my Zoom cut out? So there was a part right before you were talking about the April rent, or I couldn't hear you because I
Okay,
had to.
so the supersedious bond,
Okay.
I've awarded in the matter, which means that if you want to keep going, if you do appeal this, within 10 days of today, $3,942 in the registry of the court. And then thereafter, as the appeal continues, monthly amounts due by the 5th of the month in the sum of the monthly rent of $1,314 would be due in the registry of the court by the 5th day of every successive month thereafter.
Okay, got it.
All right.
Thank you.
Thank you. I appreciate it.
Thank you, Your Honor.
All right.
Bye.
Y'all have a great
Thank
rest
you.
of the day. Thank you.